Yesterday, which was May 16, 2023, Alex Murdaugh's law team filed a 27-page novel of excuses and shenanigans to try once again to get Alex off the hook for his largest theft against a client, the Gloria Satterfield case. This will be my fourth video on this ongoing case as more and more motions continue to pile up. So join me now as we explore this latest motion, Defendant Murdaugh's Rule 60B, Motion for Relief from Judgment. On this season of The Other 55%, the trial that consumed the entire true crime community and beyond.
And I could see his brain on...
Generating millions of dollars in fees, that was not enough for you.
I know you have to see Paul and Maggie during the night times when you're attempting to go to sleep. I'm sure they come and visit you.
All these people on these two exhibits, these were real people that needed this money, is that correct?
I'm sure they did.
Somebody going to check them?
Yes, sir. They've already checked them.
They did check them?
Yes, sir.
It's official that they're dead?
Yes, sir. That's what it looks like.
Oh, and it might not have been you. It might have been the monster you become.
The murder trial is over, and the next trial for his financial crimes is about to begin. We've heard the number of indictments. Let's go beyond the numbers. As Creighton said, these are real people. Let's hear their stories on Murdaugh The Victims with Cassidy O'Connell. First of all, let me apologize for my voice today. I've been traveling and I caught a little cold. First, we spent a little time in Amsterdam, one of the prettiest cities. And then I made it down to South Carolina to meet Assistant Attorney General Sir Creightonwaters himself, the prosecutor for the Murdaugh murder trial. If you're new to this saga, Gloria Satterfield was a housekeeper for Alex's family for over 2 decades. She kept house for and helped raise his sons in that time. She met her untimely death at the bottom of the Murdaugh stairs. Alex promised her sons, one of which is special needs, that he was going to take care of them and get them a settlement. He did in fact get a very large settlement for over $4 million, which he promptly stole, took the lion's share of, and split the rest between his attorney friend Corey Fleming, whose trial, by the way, for this crime is scheduled for September 11th of this year, and Chad Westendorf, vice president of Palmetto State Bank. I have 3 videos here on my channel about this case already. If you want to know all of those details, I'll pin links to them in comments. But the important facts are that Alex told his insurance company that she was not there to work but to collect a check, and that his dogs had jumped on her, causing her to fall. He also used threats that he would stand up in court in Hampton County, which is a place that's known for their large settlement wins, and that he would take responsibility publicly, forcing them into a much larger than usual settlement. Now, keep in mind, he didn't do this for Gloria's kids, but for his own bank account. Now that he's being called to trial for these financial crimes, he and his law team, Dick and Jim, are trying every stunt and shenanigan they can to get him out of having to pay it back. Their first stunt was to say that since attorney Ericbland had gotten a settlement for them, that he couldn't possibly be expected to pay them since you can't make a claim twice for the same event. However, that settlement was paid by everyone else but Alex, because none of them were minding their own stores correctly, and this allowed Alex to be able to pull this thievery off. They paid for their parts, but that did not absolve Alec from his responsibility. Alex stole money that he now has to pay back. It's basic justice. So that brings us to why we're here today, this 27-page motion that reads like a trashy novel. On page 1, everybody, where half the page is already taken up by the court caption, we still find the defense team was able to pack in references to the opioid addiction, Alex being shot in the head, and his inpatient drug rehabilitation. Can I just ask why Dick and Jim think that the court or any of us are silly enough to fall for any of this obvious pity ploy? Now I'm going to save this first paragraph for a bit later and jump in at the introduction, where we find for the umpteenth time Dick and Jim start throwing these things in. starting with this alleged opioid addiction. They say it spiraled out of control after the deaths of Maggie and Paul. What it should say is after he viciously shot and killed his wife and youngest son. But by the way, since when is an opioid addiction an excuse for committing terrible crimes? What world do they live in where using his criminal drug habit will make his actions more explainable? And then, of course, we're reminded that he was shot in the head by Cousin Eddie. Now, I was planning an in-depth video about Cousin Eddie, but we're going to have to get into some of that today, since they've reopened this can of worms. They stated in court that Alex's skull was fractured by the shot to his head, and that he had to be airlifted to a hospital due to the gravity of the gunshot wound. All of this without a stitch of proof. Let's listen to Cousin Eddie's attorney describe this. Describe this event.
I have so many questions I want to ask you about that. And I know there are so many that you really can't answer right now, but it appears, that he obviously, we can see the photographic evidence. He met Alec Murdaugh there on the roadside that day.
He absolutely did.
Something transpired. And then Alec Murdaugh suffers some type of wound and Eddie takes off. Why didn't he stick around? Are you able to tell us that?
Well, so I can tell you that it's certainly our position that the wound that Alec suffered was from hitting the asphalt with the back of his head, that he did not sustain a gunshot wound. Dick likes to wave around these very minor pieces of the medical records, and he only wants to put in portions and parts, because what those medical records consistently say is that person, Alec Murdaugh, reports. So these are all things that he's reporting, but they absolutely don't say there's a gunshot wound. They say that it reports to be a gunshot wound. It's whatever fits with their narrative at the time. But in my opinion, that is not a gunshot wound.
So there's potentially this struggle over a firearm that goes off, and Alec Murdaugh falls backward and hits his head on the ground, and you contend that's how he injured himself. It wasn't a gunshot wound? Absolutely, on the asphalt. That's certainly been my position ever since I've been involved in this case. And so, but then why does Eddie leave? Well, because he's in fear. Because this is somebody who is absolutely gone crazy. And in my opinion, before Eddie left, I am fully convinced that Alec planned on killing him on the side of the road. I think that would have made his life so much easier. The murders could have been solved. He would have said, oh, he was coming to finish off the job or whatever, and all of his problems would have gone away. But with Nate Tootin, talk about cashing checks, because that's exactly what Eddie did as well, was cash checks for Alec. Eddie was a convenience for Alec to get what he wanted to get done. When people call Eddie a drug dealer, he's got to be the worst drug dealer in the world, because he had one client, and that client was Alec Murdaugh.
There's also body cam footage of the cop who interviewed him immediately after the alleged shooting. And Alex is here, he's speaking so loudly and in his typical demeanor, over-explaining details, rambling. One would think that the amount of pain and typical symptoms of a fractured skull, especially from a gunshot wound, that it would have him displaying some sort of sign of distress, or at least speaking in a lower volume that would cause less pain to your head. I would think a gunshot wound that fractured a skull would also cause a fair amount of shock. But we see Alex here just as he appeared on the stand.
I pulled over, and this car went by me, and I was paying a lot of attention truck, but then it turned around, came back. A real nice guy, acted like, and I turned my head, and boom.
Okay. You know what kind of gun it was?
I don't know what kind of gun it was, but it sounded like a shotgun, even though it was so loud. It didn't sound like a 22. I know that's what they think it is, but it didn't sound like a 22.
It looks like a small caliber hole. Yeah.
Small caliber?
Yeah, small caliber.
But it was extremely loud.
What's your name?
Alec Murdaugh.
Okay.
I'm not a doctor, but everything I've looked up says that a fractured skull takes a minimum of 6 weeks to heal. That's minimum. It often takes months. In spite of the fact that we can clearly see the back of his head in the following clip, where we find Alex in court 12 days after the incident. That's right, 12 days after. There appears to be no wound of any kind. Knowing his defense team and their constant requests for more time, surely they would have brought this before the court and asked for full recovery time for his fractured skull if Alex had a true diagnosis of one. But here we are 12 days after he was supposedly shot in the head, sustaining a skull fracture, and there isn't a visible wound at all. And the attorneys don't mention it. They don't bring it up as a reason to postpone this trial. It just proceeds as normal, which is really hard to believe 12 days after a gunshot wound to the head that causes a skull fracture.
All rise. Court's now in session. The Honorable Judge Tanja Alexander presiding. You may be seated.
We also learned from law enforcement that the moment a gunshot wound to the head is called into emergency services, a helicopter is immediately dispatched. So, proclaiming he was airlifted is not proof that the wound was serious, or was even in fact a gunshot wound as claimed. It means someone reported a gunshot wound to the head, and they were simply following protocol. So until medical records are shown that specifically say that Alex sustained a gunshot wound and has an actual diagnosis with some type of imaging proof of a skull fracture, I'm going to call shenanigans. As for bringing up these 3 things, especially on the first page, what does any of it have to do with this case? These dates and events do not coincide with Alex's testimony about Gloria's accident, so what's the relevance? Why are they mentioned, let alone being the lead introduction in this document? Objection, Your Honor. Relevance? Page 2 finally gets to the point they want to make, and that is that Alex's confession is void under South Carolina law, specifically Rule 60, B, 3, and 4, and therefore should be vacated. Rule 60 is the heading relief from judgment or order, and Part B3 addresses mistakes, inadvertence, excusable neglect, newly discovered evidence, fraud, etc. The court may relieve a party or his legal representative from a final judgment, order, or proceeding for the following reasons. 3 mentions fraud, misrepresentation, or other misconduct of an adverse party, and 4 says the judgment is void. Now, it would seem to me that this code is for the benefit of the one who's actually been wronged by fraud on behalf of the opposing party. In this case, Nautilus Insurance, since they were the ones that were defrauded by Alex's testimony. How is Alex, the one who put fraud on the table, going to now say, I want to correct these errors and set the record straight, because it benefits me now to do so? Rather than being punished for his alleged crimes of fraud and misrepresentation, he wants to be rewarded, and his victims, Gloria's sons, be punished. In my opinion, this is not some I found Jesus and want to wash my sins moment. This is another attempt to not have to pay Gloria's sons the money he stole from them, and it's insulting that they're twisting a law that's meant to protect victims of fraudulent testimony as a possible way for him to weasel his way out of this. On page 3, we find Alex's new version of events. In a timeline, we see the unfolding of events, which, by the way, are covered in my previous Gloria Satterfield videos, so I'm not going to review them all now. You can always go back and watch those. Now, he says that according to investigations of her death by the insurer, Miss Satterfield's medical conditions and the side effects of medications taken for these medical conditions caused her to faint and fall down the stairs. Now, this part was quite interesting to me. As I've stated before, I was always suspicious of Alex's story and already saw it as a greedy act to obtain as much insurance money as possible. However, a documented liar who lied about his being present at the scene of the murder of his wife and son, who lied about a suicide murder plot, who lied to his clients one after the other to steal their money, who lied to his law firm, including his own brother, who lied to judges, now is at last telling the truth, especially when it's so self-serving to do so. But here's a segment of the mediator's statement. Here the mediator, John Austin, states, plaintiff, Miss Satterfield, reported to neurosurgeon Dr. D'Agostino that she fell down several stairs and she did not know why she fell. We know the plaintiff had diabetic neuropathy and had complained of tingling in her feet. We also know that plaintiff was on several medications, including amlodipine and hydrochlorothiazide, which have side effects including dizziness. In fact, amlodipine states severe dizziness is one of the more serious side effects. There are multiple reasons why plaintiff fell. In addition to the medications and her diabetes, Miss Satterfield could have simply lost her balance. However, Alec Murdaugh has maintained that when he first got to the plaintiff, she reported that one of his dogs tripped her up or somehow caused her to fall. Alex's testimony is the only evidence that his dogs had anything to do with the plaintiff's fall, and he personally feels very guilty about it. Again, the EMS workers did not see any dogs, and no one said anything to them about a dog being involved in the incident. For purposes of mediation, I do not intend to argue liability. I do not see a benefit to Alec to argue that the plaintiff may have simply lost her balance when he says his dogs knocked her down. However, despite the plaintiff's young age, I do not believe the fall was the sole cause of her death. Her underlying health conditions also contributed to her death. But then it goes on to say, moreover, if we have to try the case, I will do my best to show that Alec's dogs had nothing to do with her fall. That being said, we want to resolve the case. We recognize the very liberal nature of the venue, Hampton County, the notoriety of our client, Alex Murdaugh, and his contrary opinion regarding the cause of the plaintiff's fall, his dogs. Then, on March 22nd, it mentions the adjuster blaming Alex and being angry with him for causing Nautilus to pay far more than it expected. But I like this interesting little note. At defendant's behest, neither Mr. Satterfield nor Mr. Harriet were present at the mediation. In other words, Alex did not want Gloria's sons present for the mediation. If you've watched my previous Gloria Satterfield videos, you would have seen attorney Eric Bland, during the deposition of Chad Westendorf, state that Alex had used his power, prestige, and the reputation of Hampton County as a threat to get the most he could from a settlement. We now see black and white proof of this being true. But again, although this may be true, isn't it up to Nautilus to pursue this if they were in fact defrauded by Alex and not Alex's right to use his previous fraud to help himself here? The timeline continues and we come to page 9 where they quote statements Eric Bland made in an email to CNN criticizing SLED. But wait, wasn't Alex's whole alibi story about not being at the kennels before the murders because he was in such fear that SLED might do him bad like they did his friend bad? Now he's bashing Eric when I don't see anything Eric says here coming close to the bashing that Alex, Dick, and Jim gave SLED during the murder trial. But suddenly there's so much concern for what Eric might be saying about SLED. But anyway, they draw attention to this last sentence here. The claim was not fabricated, and Alex appropriately referred them to an attorney. And the hypocrisy gets even richer here, because as most of us know, Fitz News, which is where Will Folks, Mandy Matney, Liz Farrell, and later Eric Bland have spent years uncovering Alex's corruption. It's basically defense's nemesis. But here, Dick and Jim are quoting from them by saying, Will Folks of Fitz News wrote, an attorney following the case closely told me Bland was worried about his clients having to cough back up the money to the insurance companies, which they would have to do if the claim was fabricated from the start. So basically, they quote from a website that they regularly deny is truthful. Not just that, but they quote from a reporter at this website who said an unnamed attorney, which could literally be any attorney, including themselves. So an unnamed attorney that follows the case closely told me that Eric Bland was worried about blah 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 blah. Or, in other words, a reporter we constantly accuse of spreading falsehood from a website we constantly claim to be reporting false information about us and our client said that an unnamed attorney we know nothing about expressed his opinion about what he or she thinks Eric Bland might be feeling. And we're going to put that right here in our motion as factual evidence that our lying, stealing, murdering client is now telling the truth. Did I get that right? Objection. Hearsay. Objection. Ridiculous. Then he continues to list mean things that Eric Bland has said about Alex. Basically, Eric said, don't let this guy out where he can hurt others. Hold men who steal with the pen on the same level as men who steal with the gun. Alex is a liar and a cheat who stole. But, didn't the court find him guilty of murder? Didn't Alex admit to lying and stealing during his trial? Aren't these things true? Then he quotes again from Fitz News that he just used to support a claim, but this time in a bad way for saying something bad about his client. Make up your mind. Personally, I find these quotes from Eric to be so on point that if I were the defense, I wouldn't want to make them more publicly known. Myself, for example, I don't subscribe to Fitz News, so I had never seen these statements. But now, thanks to this motion, I have. But this statement, of course, Mr. Bland knows Mr. Murdaugh is incarcerated and all his assets are in the receivership that Mr. Bland requested the court impose. Mr. Murdaugh cannot keep any money, stolen or otherwise. That Alex can't keep any of the money? This is quite a statement, since Alex himself, when he was faced with the lawsuit for the boating accident that killed Mallory Beach and injured several others, told attorney Mark-Tinsley that he didn't have any money. And that was in fact the catalyst for the financial audit that led to the discovery of all of his financial crimes. By Alex's own admission and by the bank transactions of which I've already listed so many of, that money is long gone. It's not being held somewhere. Alex spent it, which was why he was in a continuous cycle of stealing from his clients. He'd steal a few million, spend it, steal some more. What a ridiculous statement to make. Now we get to what they really want here on page 13. They're moving once again for a gag order to be placed on Attorney Bland, as they tried and failed to do previously. The next few pages outline the settlements that Eric Bland won for his clients from other defendants, for example Bank of America and Corey Fleming, as if begrudging the Satterfields for winning these, and also as if the wins negate the fact that Alex stole from them and he is the one accountable for that. He's been defending bankers and fellow attorneys, taking all the blame, saying that, for example, Russell Lafitte, Corey Fleming, and Chad Westendorf had no idea what he was doing. But now he feels it was okay that they all paid off the Satterfields. And since they have, why should he? Shouldn't it be the other way around? If he's claiming all the guilt, shouldn't he say, give their money back? Let me pay, instead of, well, they've already paid, so why should I pay too? Page 17 states that at some point during the trial, defense counsel becomes aware that the dog story is false. So after the trial, Alex admits that he lied, and this was covered in a previous video I made. And now, based on this liar, by his own admission, based on his new statement, the judgment is void once again, citing South Carolina Rules of Civil Procedure, Rule 60B, and they cite a bunch of court rulings, including out-of-state cases, that would support this, in their opinion. And then goes on to page 22, where they even attempt to pretend that one of their concerns is that it will obstruct the recovery of other victims of Mr. Murdaugh's financial crimes, which is a plain due process violation. Now, are these men really concerned with Alex's victims? Let's turn back a few pages to page 18, where they assert an affirmative defense that Nautilus has failed to join the plaintiffs, who are necessary parties. The plaintiffs being Gloria's sons. So are we to understand that Alex is stating that he lied about the dogs to get a settlement that they never received, because he stole it and spent it, and now he's angry that they're not being further victimized by being brought into this suit? Not only does he not feel he owes them anything, but he wants them to have to give the settlement money back that they did win from other people that Alex claims are innocent and were unaware of his schemes. But also, on top of this, they need to be added to the suit so they can pay the insurance company. Is that the gist of this? Don't sue me, sue my victims? I hope the judge is as outraged as I am right now. In my view, this man couldn't care less about his victims. He's not asking for this to go away on behalf of his other clients. He has shown us how little he cares for them. He wants a smoother path for himself and will say anything to make that happen. We now move on to the bottom half of page 22 to once again excuse Alex's behavior that was brought on by an alleged crippling drug addiction. Since when is that a defense? Since when do we say, this man's guilty of murder, but it's okay, he was a drug addict. This man is guilty of rape, but it's okay, he was a drug addict. This man beat his wife and his children, but you know what? It's okay, he was a drug addict. Shenanigans. It goes on to say that Alex didn't steal from the Satterfields. He stole from Nautilus. But that's a wild assumption that can never be proved true. That assumes that without Alex telling the part about the dogs, that there would have been no settlement at all. There's no possible way defense can know what sort of outcome an honest trial would have brought them. This case is so tainted, it's impossible to ever know that. Perhaps it would have been less, but no one can state how much it would have been. And let's not forget, all of this hinges on the word of a convicted murderer who has already admitted he's lied under oath, in depositions, while being questioned by police multiple times, and in real life to friends, family, and colleagues. How does anyone stake anything on the word of such a man? Surely a judge will not turn all of this around on the word of a man who has changed his story so many times. I'll be anxiously awaiting the response to this motion, and as soon as I hear, I will update you as well. Until then, this is Cassidy O'Connell saying stay well and stay tuned.